Jenny Brown. I am an attorney in Georgia, and what we're doing is we're doing videos breaking down the differences in family law from state to state. It always amazes me how different laws are. And with me today, I have Cary Jacobson, and she is an attorney in Maryland. So Cary, go ahead and introduce yourself.
Hi, yes, thank you so much for having me. Sorry about the technical difficulties. I am Cary Jacobson with Jacobson Family Law, and we are located in Maryland. We are completely virtual, so we work with clients all throughout Maryland.
Awesome. It's funny, COVID changed that so much for us. Like before, at least here in Georgia, before COVID, doing anything, like you had to do a motion to appear telephonically, and then 99% of the time they were denied. And judges were like, how the heck am I supposed to do a hearing without you being here?
Yes, and fortunately for us, we don't do any litigation. And the one thing that was really wonderful with COVID is now all of the uncontested divorces in court are virtual. So they're by Zoom or telephone. So it's been wonderful.
That's awesome. Is that statewide?
It is, at least for all of the counties that we have worked in so far.
Okay.
Yes, it has proven to be a time saver for both the clients, the attorneys, and the court.
Yeah, interesting. So we'll just jump right in. Let's start out with talking about when a child is born outside of a marriage. So a mom and dad are dating, they have a child and they're not married. What is the law in Maryland as far as the father's rights to that child? Does he have any? How does that work?
So generally, really the best thing to do would be to do a paternity action to confirm whether or not he is the legitimate father. And from there, he can petition for custodial rights if there is a dispute between the parents as to what that's going to look like. Provided that he is, in fact, the biological father, honestly, both parents are on equal footing until there is a court order that specifies otherwise.
And so in Maryland, if he signs the birth certificate or if the parties agree for him to sign the birth certificate, do they have equal rights at that time until there's an order otherwise?
Yes.
Okay. So that's interesting because Georgia law is the exact opposite. So here, if they sign the birth certificate, all it does really is it gives the right for the mother to go and put the father on child support, but he doesn't have, the dad has no legal or physical rights to the child until he files a legitimation.
Yeah. I mean, there's the logistical side of where the child is, but for all intents and purposes, they have equal rights.
Okay, that's interesting. So if the parties don't, let's say the parties don't agree and that somebody has a child out of wedlock and the mother just happens to have the child physically because she had the child, what does the dad have to do to get parenting time to ensure he actually gets to see that child?
Yeah, so it would be an initial step would be to take the paternity test to confirm that he is the parent. And after that, it is filing a petition for custody or custodial access with the court. Here in Maryland, anytime there is custody at issue, as long as there hasn't been, allegations of domestic violence, the court's likely going to order the parents to undergo parenting classes. It's not how to parent a child, it's how to co-parent with one another. And they're also going to require them to participate in custody mediation.
Okay. And do y'all have a default to 50-50 custody in your state? Is that really, or is it the best interest standard? What is the rule in Maryland?
Yeah, Maryland follows the best interest standard. There is not a default. And really it's looking at certain factors to determine which, what the best interest of the child is.
Would you say that, so here in Georgia, joint 50-50 is not the norm. We very much still have what I would say a regular parenting time schedule where one party has the majority of the time and the other has usually liberal parenting time. It is usually more than every other weekend at this point and shared holidays, but 50-50 is certainly not our default. How is Maryland just generally on how they do parenting time with children?
I would say generally, we tend to be more of a shared access schedule situation. I would not necessarily, the default is 50-50. But unless there are extreme allegations against a parent, you're going to see more than the every other weekend. I would say it probably tends more to be closer to like a 60-40, you know, and then gradually going into a 50-50.
And if somebody has a 50-50 in Maryland, does that change their child support if you're looking at that schedule versus someone that does have a more traditional every other weekend schedule?
Yes. So Maryland actually changed our child support guidelines because we had what a lot of people refer to as like a cliff, where what we referred to as primary parenting, if the non-custodial parent had less than we call it, it's based on overnights. If they had less than 128 overnights, so usually that is your alternating weekend kind of schedule, it was a huge difference between that and 129 overnights. So we've now changed it to where it's about 25%. The overnights are now 92 throughout the year, and it's more of a gradual cliff. So there's not as much conflict between parents in going from one, schedule to the other. As time increases,
go up, then your child
exactly.
Down.
Exactly. Yeah. So the more time they get, the less child support overall, but it's not the sudden drop off cliff that we had before.
Okay, that's interesting. So Georgia, we have a combined household income on our child support worksheet, and what it does is it gives us a presumptive amount of child support, and then for 50-50 or for any additional parenting time, it really just said, our statute just says that it's up to the judge's discretion, which gives us very little direction. So it's a huge bone of contention because a lot of different people differ on what they feel is fair in that situation. Right. When you've got a 50-50 schedule.
Yeah, our child support guidelines, when they were changed last year, now the combined yearly income is $360,000 for the guidelines to be presumed. If they're over that, then there's a little bit more leeway in deviating from the guidelines.
Right. So back to the children out of wedlock. Is there a period of time that if the father does not take action, then he can lose his opportunity to take action with that child if a child's born out of wedlock?
Not really. It makes it more challenging for him to get, more custodial access if there is a delay. But, there have been scenarios where a parent may not have been in the picture for a period of time, either because they didn't know about the child, or because, didn't want to be or wasn't able to be in a position to parent the child at that young age, and they come in later. They still can petition later to have rights. It's just that their custodial access time is going to be different than if they had been parenting the child the whole time.
Yeah, see, and that's different too for us because here in Georgia, we have the legitimation statute actually says that the judge has the right to deny a father the ability to even legitimate, and they have to follow certain factors, but one is the amount of time it took him to file the legitimation and the contact he's had in the child's life before that time. Mm-hmm. So there is a possibility if you wait for years and don't have contact or aren't financially supporting your child, that the court here could actually deny that father's right the ability to have a legal or physical relationship with the child.
That's very interesting. Yeah. For here, the child support, what is paid or not paid, does not necessarily impact what the access schedule is going to be. Meaning if a parent just decides not to pay or chooses not to pay or is unable to pay, that does not necessarily impact whether or not they're going to be able to have access.
We've got a few questions related specifically to custody, and I'm going to focus on those, and then we'll jump to the issue of divorce and how that changes from case to case. So one question that someone asked is, how often do men get full custody or get half or full custody, and what increases their chances? What would you say in your experience?
I definitely have had scenarios where father has been granted primary physical custody. And I regularly see equal access with parents. Things that increase the likelihood that that's going to happen: involvement in the child's life, doing those day-to-day parenting activities, and really sometimes as far as getting more time, it's going to be because there's issues with the other parent. Maybe it's a substance abuse issue. Maybe it's that they have not been involved. And so that increases dad's likelihood of having additional access.
Yeah, I agree. I mean, I've had numerous cases where I've gotten primary physical custody for the father, and usually there's some issue with the mom, right? If it's drugs, it's alcohol. Sometimes it's a severe inability to co-parent, right? If she has
Absolutely
zero desire to foster that relationship with the child and with the father and with both parents, and the dad can show that he has that ability to do that, that's been a major factor. But I think what you said is really on point for here in Georgia, and probably really across the United States, is being involved, and being involved as much as you can and as early as you can is huge. Because if you're coming in 5 years later and you've never taken the kid to a doctor or a dentist, you don't know where they even go. I mean, those are big things for a judge when they're deciding how much time should you get with this child moving forward.
right. Absolutely.
What is the experience when one parent always finds ways to hinder electronic communications? I'm guessing they're asking between the child. So what can somebody do if they're having trouble communicating with the child when the other parent has parenting time with that child?
So I do a lot of mediation, both court ordered and private. And sometimes what can be very helpful is for parents to put into an agreement or to come up with a protocol as to what and how communication is going to happen. For some families, that needs to be very specific. Parent is going to call child every day at 7:30 p.m. And for other parents and couples, it can be very, ad hoc. And it could simply say that each parent's going to have an opportunity to speak with the child while in the other parent's, custodial access. So it really depends on your particular situation. But having a specific protocol to reduce conflict can be helpful, so everybody's on the same page as to what that looks like.
Yeah, because sometimes people struggle with, a lot of the times our parenting plans will say the non-exercising parent can have communication at reasonable times for reasonable hours. Well, the problem is people define reasonable very differently.
Right.
So sometimes it does help, especially in those situations where parties have trouble agreeing to have a specific time. But what I always try to tell people, and I do a lot of mediations too, is I always try to tell them, think about also the disruption to the child. So I've had clients before that are like, I want to call in the morning and night. And I'm like, okay, well, is that really what's best for your child? Because the morning, I have to get 2 kids out the door for school, and I feel like a drill sergeant in the morning, right? So adding a required phone call in the morning would be mayhem for my kids.
Right.
And so I try to tell people that too, think about it from, yes, you want to communicate with your child, but also what's going to be the most productive and the most helpful for your child, and when that communication is going to be.
Absolutely. And, it depends on the age of the child as well, because it may be a scenario, where it's a younger child. A parent should not expect to have a 5 or a 10-minute conversation with a kid who is under 5. That's just not going to be a productive situation. And then as kids get older, yes, they may be able to have a longer conversation, but they're honestly, wanting to do their own things, play with their friends, do their stuff. And so it's really a chance to touch base. How was your day? And have an opportunity to, just touch base with them.
Exactly. Yeah. I mean, and the majority of the time, the reality is when you're FaceTiming a kid, they're putting emojis on their own face and looking at them. And then at a certain point, they're too cool to talk to their parents. So it's
exactly
stages of communication with kids. So let's transition a little bit into divorce. Does Maryland have a fault ground divorces, or is it all no fault?
we're actually in a state of transition on that. So legislation was just passed in this session that will go into effect in October 1st, that is doing away with Maryland's fault grounds for divorce, and we will only have no fault grounds. So we currently have adultery, desertion, cruelty of treatment. All of those are going to be going away, and we will just have irreconcilable differences, a 6-month separation period, which can be in the same household. So we'll see how that plays out and what that looks like for families. And we currently have what's called mutual consent. And that is a ground that allows couples to obtain a divorce, even if they're living in the same household, as long as they have a signed separation agreement that resolves all of the issues between the two of them. So there's no, in that particular scenario, there is no requirement that the parties be living separate and apart for the divorce to be granted.
Previously, did Maryland have a requirement that they had to live separate to actually be divorced?
So in the past, yes. The mutual consent ground has come about in the last several years. If parties are not able to reach an agreement on their own, then they did have to have a 1-year separation period.
Okay.
In order for the divorce to be granted.
So here in Georgia, we just have to show that the parties have been in a bona fide state of separation for 30 days. And that can be, they could even be sleeping in the same bed and say, oh, wow, we've been living in a bona fide state of separation. And they could get, we divorce people all the time where they're still living in the same home and then they have to sell the home X amount of time after divorce. So that is completely different than our law here. And we do have 13 grounds for divorce. So we have irretrievably broken is, used the most. But after that, we have adultery, we have cruel treatment, we have habitual drunkenness, we have drug use. So we've got a lot of grounds. The big ones are irretrievably broken and then adultery. We do have abuse, cruel treatment. Those are used not near as often, but we do have them. So now that Maryland is getting away from the fault ground divorces, can behavior such as adultery or cruel treatment, can that still skew the outcome of the divorce?
In theory, yes. And I say in theory, it is one fault grounds. What led to the demise of the marriage, or what led to the divorce, is one of the 10 or 11 factors a judge has to consider when determining property division or alimony. All of that being said, the reality and the practicality of it is how much weight each judge puts on each of those factors is completely subjective. And honestly, in my experience, most judges take the easy way out and do a straight 50-50 division of assets, of those marital assets. And, we here do not have guidelines for alimony. And so you may have 5 judges in a courthouse that hear the same exact pattern and they do 5 completely different things. So it's really a coin toss.
And that's where our states are very similar. Actually, we are the same. So we've got this great calculator for child support that gives us general, guidelines, but alimony just is one party's need, the other party's ability to pay. So you could be just like you said, you could be in a courtroom and you've got, a woman judge who's worked her entire life and she works and she raises children. And then next door over, you've got a male judge who has had a stay-at-home wife his entire life, and they might rule very differently on what a fair amount of alimony is. And we don't get to pick our judges. So
exactly,
whoever your case gets assigned to. So last question on divorce, and then I've just got 2 remaining questions, and then we can answer any we have still in the chat. But for divorce, here in Georgia, everything that is earned during a marriage is marital property. And there are some exceptions, separate property for inheritance or any personal injury claims, certain personal injury claims. But in general, whatever is earned during a marriage is marital property. Is that the same with Maryland, or does title control? What is your laws for what's marital and what's not?
Ours is very similar. So it's anything earned or acquired during the marriage, regardless of how it may be titled. Our exceptions tend to be anything either person owned prior to the marriage, um, anything that they received by inheritance, as long as they have not commingled it, things that they may have received by gift, and those things that may have otherwise been excluded by a contract. So if they have a prenuptial agreement, or if they have a separation agreement that specifies, how things are going to be handled, those things would be carved out. But for all intents and purposes, if they purchased it or earned it during the marriage, it is a marital asset.
Yeah, and the commingling gets messy.
Absolutely.
When you're trying to trace funds and figure out how that works. It gets very difficult, and what's then converted to a marital asset and what's not. So
right.
It seems pretty similar on that point. My last question is about relocation. So here in Georgia, our parenting plans typically say that if you're going to relocate out of the state, then you have to give the other party notice. And it's usually, by statute, it's a 30-day notice, but a lot of most people put 60 or 90 if they're moving out of state in their parenting plan. But how it works here is you have to give notice to the other parent that you're relocating. So let's say the custodial parent's relocating to Maryland, for example, and they give the non-custodial parent notice. They don't have to get permission from the court to then move. They've given the onus is on the other party to file a modification, trying to modify their parenting time. Is Maryland the same, or do you have to actually get permission to relocate if you've got an order there?
So it is very much the same. I think our statute requires 90 days. Not all of the agreements will include a provision, but I think that basically, if custodial parent gives notice, then that puts the onus, as you said, on the non-custodial parent to basically block the move. And so the statute allows for a expedited hearing to at least hear whether or not parent can take the kids, for that relocation. I will say that for the most part, the relocations are generally frowned upon, but there are definitely exceptions where, parents are permitted to relocate with their kids.
Definitely. And ours is very similar. So ultimately, it's up to the judge if the move is going to be in the best interest of the child. But the judge weighs very heavily that relationship with the other parent and maintaining that relationship. And so if you're just moving because you got a new boyfriend in Maryland and you want to go see if it works, like, that's probably not going to go very well for the moving parent. But if you can show a substantial reason, then they might allow that. See, one person said, what do you do if your child tells you a grown man, I think it says, scared her into her bedroom? My suggestion would just be, if there's any sort of abuse in a home at all, we call it defects, or you get with the police, right? If there's any sort of abuse, sexual or physical, you want to go to the authorities as soon as possible to get your child help as quickly as possible. Cary, can you still hear me? Oh, I think I might have lost you, or you might be frozen. I'm going to answer a few more of these questions, and then if you do hear me, just jump right back on. We've got a question that says, thoughts on modification for full custody if the non-custodial parent...
So I think it's my internet connection. I apologize.
Oh, that's okay. Can you hear me? There we go. I think you're back. Can you hear me?
Is that any better?
A little bit. So we've got a question on what is our thoughts on a modification for full custody for the non-custodial parent if the custodial parent moves an hour away. My thoughts on that is that would probably be a pretty difficult case with those facts alone. I don't think an hour move would grant a change in custody. It might be a different situation if you've already got a 50-50 schedule and the party's moving and it won't allow that 50-50 schedule anymore. But I think that might be difficult to ask for full custody just because of a 1 hour move. Cary, do you have any thoughts on that? See, we've got a question. My husband wants me to pay him the down payment he put down on our.
I agree that it.
Oh, can you hear me? I think your internet connection is going out. Thoughts on a modification if the custodial parent moved his girlfriend and teenage daughter in? Can you hear me, Cary? Oh, I can see you now.
I'm going to try a different spot. Okay, I'm going to try a different spot. Maybe that will help.
Can you hear me?
Yes, I can hear you.
Okay. So a question we just got on, what do you think about a modification if the custodial parent moved his girlfriend and teenager into their home?
I don't see that being a reason for a modification unless there's some negative impact on the child.
I would tend to agree, just given that very limited information. Obviously, there could be a lot more to the story, but if there's a negative impact on the child and this person is a danger or they have a major criminal history or something like that, but just the move-in alone, I'm not sure that would warrant a modification unless, we do have something here where some people put a morals clause in a parenting plan that says you won't have overnight guests of the opposite sex or a romantic partner in the presence of the child. So you could have a contempt there, but I don't see that as a basis for changing custody unless there are other factors.
Agree.
How do you deal with a toxic co-parent that takes every opportunity to badmouth the other parent?
These are always very challenging, right? Because you can't necessarily do anything about the other person's behavior. But if, all you can do is make sure that you are not the parent who is doing the same thing, kids pick up on this, and kids absolutely trend towards the parent who is not talking negatively about the other parent. So, I here in Maryland, I am a best interest attorney, which is an attorney that can be appointed by the court in custody disputes between parents to represent the child. A lot of other states call it the guardian ad litem. Maryland has to be different and call it something different. But that's always something that I'm looking for. And so it's very important that not to just do it because the other parent's doing it and feeling like you have to defend yourself. It's really redirecting and showing the opposite behavior. And if at all possible, getting that child into therapy so that they have a place to have conversations with people who are not, the parents, and have a safe space.
Absolutely. And I completely agree with you. I think that while the parent who is bad mouthing the other parent may have a temporary win, right, until the child really gets the ability to see what's happening on their own and realize that it's really because that parent is just still bitter and really not thinking about the child's best interest, eventually they really do see through that. And kids are so smart that I think sometimes parents don't give them credit. But another huge thing is also set your boundaries with communication with the other parent. You're not in a relationship anymore, and you don't have to respond to every single text message or every single allegations, right? So the more you keep it just about your children, the logistics, and not the drama, a lot of the times eventually it goes away.
Absolutely.
Let's see. So I want to ask you one question just because something that you had said. So we have guardian ad litems here. Here in the state of Georgia, most attorneys most guardian ad litems are attorneys, and essentially they're appointed as advocates on behalf of the child. So they don't represent mom, they don't represent dad. They are there to I always say they're an arm of the court, right? They're
Right.
looking at people, they're looking at evidence, they're talking to third parties, and they're going to tell the judge, hey, based off my investigation, this is what I think is in the best interest of the children. Is that similar to what you do in Maryland?
Yes. We actually have technically three different options for this role. So the best interest attorney is representing the child, and it's not necessarily what that child wants. It is what they believe to be in the child's best interest, and we can make a recommendation. So we are able to put on evidence just like mom and dad's attorney, and make a recommendation to the court. That being said, just like any other attorney, the court does not have to listen to us. And ultimately, the court makes the decision based on the evidence that is presented to them as to, what they think is in the best interest. Really, I see my role in that space is helping the parents try to come to a resolution before they have to get to trial. And hoping that they can resolve it outside of that. We also have what's called a child advocate, and that's generally for older teenagers, and that is representing the child's wishes. So even if you don't necessarily agree with the child's wishes, you are appointed to represent the child's wishes. I will say that doesn't come about very often, and that role is not generally appointed. The third option is only a privilege attorney. And so that could be a scenario where a child is in therapy. Here in Maryland, we have a case that basically says that if a child is in therapy and mom and dad are in a custody dispute, that neither mom or dad can waive the child's privilege because they have opposing interest with one another. So in that scenario, the court can appoint a privilege attorney to consult with the therapist, consult with the child, and then make a determination of whether or not the privilege will be waived. And that's really the sole role of that attorney. And so many times it's in conjunction with the best interest attorney, but it can be a standalone appointment.
In what age? So here in Georgia, we've got two ages. So we have a statute that says between the ages of 11 and 14, a child may give the court a preference on who they want to live with, but the court can or cannot consider it. It's kind of take it or leave it. And then we have a statute that says 14 and older, the child gets to choose who they want to live with on a primary basis, but that can be we can rebut that presumption if it's not in the best interest of the child. Something is interesting here in Georgia is our statute does not allow a child to choose joint. So they have to elect a primary parent to reside with at the age of 14 or older if they are making that election. What is Maryland law as far as it relates to the children's age and what they can decide?
Our age is 16. And at that point, a child can petition the court themselves. Usually it's in alignment with one of the parents, but petition the court themselves to make a request as to which parent they're going to reside with. Other than that, it's really in the discretion of the court as to whether or not they will listen to a preference, and then us as a best interest attorney to decide whether or not we believe that child has considered judgment to kind of make the request. And depending on the reasons they're making the request and that sort of thing, that feeds into our recommendations as to what we think the court should do.
Yeah. I mean, in my opinion, 11 is way too young to have a child sign an election. And the cases I've been involved in, when they do, 9 out of 10 of them didn't even read what their parents gave them. And they just signed it because mom or dad was telling me to sign this piece of paper and I did. So there's major issues with a child that young signing an election and trying to decide for themselves where they want to reside. So
exactly.
This has been so helpful for me. It's so interesting to break down how different the laws are, and there are some similarities too, but we do have very, very different laws. And so I thank you for your time. You were our first of 50 that we're doing. So it was great talking to you today, though.
Thank you as well for the opportunity, and I appreciate it.
All right. Well, have a great one.
Awesome. You too.
Bye.
Bye.